consistent. Namely, the current status quo is not the path forward for the Windsor Police Service. The leadership team is committed to ensuring the public's confidence in the Windsor Police Service. This is critical to our success as police officers and as an organization. To implement positive organizational transformation, input and cooperation of all employees will be required. Most importantly, our community will be involved in the process on a continual basis. Collectively, we must renew our commitment to the core organizational values of respect for the dignity of others, pride in service, and professionalism. Going forward, we embrace community expectations as the measure of our success and shall be the cornerstone of our culture. The Windsor Police Service has one priority today, and that is renewing our community's confidence in us and trust in the service we provide. We do that by acknowledging we can provide our services with increased professionalism at every rank and in every role. Further, living and demonstrating our values and respect for others each and every day, during each call for service, and with every interaction with our community is within our control and is the path forward. The SIU has adopted the Osler definition of serious injury. The subtle difference between these definitions has been the cause or contributing factor in the delay of notification in 3 Windsor cases referred recently to in the Ombudsman report. The 4th Windsor case recently referenced in the same report was listed as a failure to notify. Recently, Justice Patrick Lesage made recommendations in regard to matters involving SIU and police. One of his recommendations was the codification of the Osler definition. This has not happened. As a result of his recommendation, however, and the confusion caused from utilizing different definitions, I have now adopted the Osler definition into Windsor Police Service directives. The details of those 4 letters. In June of 2009, a collision occurred between a marked Windsor police cruiser and a citizen. The officer was responding to a Priority 1 call and entered an intersection with emergency lights activated after stopping. His actions caused the collision. The driver of the other vehicle complained of a sore wrist after the collision, and ambulance was called to attend. The driver refused treatment at the scene. 3 days later, the driver contacted SIU directly, indicating she had suffered a bone fracture in her hand from the collision. The SIU wrote a letter to the chief inquiring why the incident was not reported. I have now responded to Mr. Scott. Had we known of the injuries, we would have promptly notified SIU. Under the circumstances, the Windsor Police Service was unaware of the injury and could not possibly have taken any other action. The second incident. In January of 2011, a male was injured while in police custody after falling due to intoxication. There was a delay in SIU notification. The delay has been attributed to interpretation of the definition of serious injury. I indicated in my response to Mr. Scott, with the Windsor Police Service adoption of the Osler definition of serious injury, the potential for delay of this type has been reduced. The third, January of 2011, a male received a broken ankle jumping out of a second-story window to avoid arrest and while fleeing from police. I concur with Mr. Scott's assessment that the delay was caused by the definition of serious injury being used by the Windsor Police Service at that time. Again, with the adoption of the Oslo definition, delay of this type will not occur. The 4th incident, in January of 2011, a male party suffered a fracture to his left humerus bone during arrest. Mr. Scott identified a delay in notification in this matter, and again, he attributed it to the definition of serious injury being used by the Windsor Police Service at that time. Going forward, with the adoption of the Osler definition of serious injury and the planned training for all frontline supervisors, facilitated by Mr. Scott's staff, these types of delays will be unlikely in the future. Service pursuant to Section 11 of Ontario Regulation 267/10 of the Police Services Act in regard to the Van Buskirk matter at my request. Review by the OIPRD will be independent and provide a clear understanding of the effectiveness of current policy and service in relation to all aspects of the Dr. Abu Hassan incident. Mr. McNeely conveyed to me that there are no further misconduct investigations on the part of Windsor Police Service in relation to the Van Buskirk matter. I plan to make the details of this independent review public when available. It is my hope this review will provide clear recommendations as the foundation for further enhancement to policy to ensure public accountability of the Windsor Police Service. As the community is aware, as a result of thorough and independent investigations conducted by both the OIPRD and SAU, a number of officers are facing serious allegations of misconduct currently before tribunal in relation to the Van Buskirk investigation. In addition, Dave Van Buskirk is facing criminal allegations currently before the courts. OIPRD also investigated allegations of misconduct that were not substantiated. Namely, an allegation of failing to notify SAU of a serious injury as per legislation. This allegation was not substantiated by OIPRD after their independent investigation. In addition, the allegation of intimidation made by Dr. Abu Hassan regarding the presence of excessive officers in the hospital while he was receiving treatment was not substantiated by the independent investigation of the OIPRD. These officers were found to be in the lawful execution of duty in relation to other matters. In addition, some in attendance were officers from other police services and present for unrelated matters. Moving forward,